All right, good morning, everyone, and welcome to my webinar on sharing safely. Can you just let me know in the chat if you can see my slides at the moment to make sure that that's working? Yep, perfect. All right. It's been quite a while since I last did a webinar, so it's very wonderful to have you with me. This is such an essential topic for online business owners and one that is unfortunately not very well understood. And that's why I am delighted that you've joined me to learn about sharing safely, how to protect your intellectual property and avoid copyright infringement when using social media for your business. I'm probably going to talk very fast because I have a whole pile of information to throw at you in this short time period, and I do want to let you room for questions. There will be a recording sent out afterwards. Any questions that are put in the chat that I don't get a chance to answer on the call, I will answer either in my newsletter or on my Facebook page, or possibly both. So I will make sure that I come back and circle around and make sure that everyone's questions get answered. All right. First, a little bit about me, a very quick introduction, just in case we haven't spent time together before. My name is Michelle Whitehead. I'm a lawyer, mediator, and mentor with my own one-woman online law firm, supporting businesses that don't fit into boxes, usually the rebels, the change makers, the healers, the visionaries. I have 3 kids who have always been homeschooled, and the pressure is on because my eldest is now homeschooling for year 11, and it's a bit of a big thing. As you can see, he's also now a whole lot taller than me. I started out working in a small country law firm where the other lawyers were focused on criminal and family law, which meant that I took on all the contracts and business disputes and anything else that had boxes and boxes of reading to do. In 2011, when I was pregnant with my daughter, I signed up to do my master's in law, majoring in alternative dispute resolution. I was completely disillusioned with my job. I was going to quit adversarial law and spend my time helping people solve their problems by being nicer to each other. I thought I asked him to turn those notifications off. I am sorry. It looks like they're going to continue anyway. Anyway, so here I am intending to quit law, become a mediator, become a channel of peace, and help people just be nice to each other. But I quickly realized that I had no idea how to market a mediation business. So I stumbled into the online world of Facebook marketing. And there I met with incredible business owners just like you who were doing world-changing work, but who didn't have boundaries. They thought contracts were scary or boring, and they didn't understand how to keep themselves and their businesses safe. So I forgave myself for being a lawyer and started building a business that would allow me to be the lawyer I always wanted to be. Now, I know you're all eager to learn about sharing safely your intellectual property on social media to promote and grow your business. So let's dive right into that. I've run a few surveys on this topic, and the results always show that the majority of my clients are promoting their businesses in Facebook groups and Facebook pages. Those who aren't generally have at least one social media presence somewhere, so Instagram or LinkedIn or Twitter. I won't have time to go into a lot of those in detail, but I'm going to touch on Instagram and Facebook. And I don't have time to read your answers out, but as I move on, please do let me know in the chat which social media platforms you regularly use for your business. So of all the business owners I've surveyed, it's very clear that most of them are keen to understand how they can protect their work from being copied or used without their permission. And even more of them are anxious to know how to avoid getting into trouble for doing the wrong thing when they share someone else's work. They worry about things like sharing an image or graphic to illustrate a post, sharing quotes or excerpts from books or articles, sharing the posts of other business owners, and even little things like gifts and memes. So before we finish today, I hope you're going to feel a whole lot more confident about sharing both your own work and other people's. Let's look at the 3 types of intellectual property. So the first thing I want to do is to give you a quick overview of intellectual property. This gets a bit tricky So please bear with me and I'll try to be as clear and concise as I can. The law recognises a number of different types of property. Most of us know about real estate, which is known as a real property. That is, things that are part of the earth or fixed to the earth. So real property is mainly land and buildings. Then there's a second type of property, which is called personal property. And those things are generally rights that are personal to you. And it includes belongings like your car, your clothes, your books, your computer, your furniture. Real property and personal property can be bought and sold or traded or stolen. And that's where the law gets involved, where there is a transfer of ownership rights over the property. Now, of those two types of property we've talked about so far, both have a physical existence. They're tangible. They can be touched, dealt with in the 3D world. But there's another type of personal property which is known as intangible property. That means it can't be touched. It doesn't have a physical existence. However, it's still a right recognised by law, which the law will enforce, and that you can buy and sell and trade with because you have ownership rights over it. And that is intellectual property. There's more types of property than that, but we won't go into those right now as I'm trying to keep this simple and relevant. So real property, personal property, and then within personal property, there's tangible property and intangible property. And so today we're focusing only on that form of intangible property known as intellectual property. Does that all make sense so far? I'm not going too fast for anybody. If you do want me to slow down, put it in all caps in the comments, just put slow down. So intellectual property is often abbreviated to IP, and it refers to creations of the mind, such as inventions, literary and artistic works, musical and dramatic works, designs and symbols, and the names and images used in commerce to identify a business or product. Examples of intellectual property include trademarks, copyrights, trade secrets, and patents. Again, there are others, but they're beyond the scope of this webinar. These legal rights allow creators and owners of intellectual property to control and profit from the use of their creations. The purpose of intellectual property laws is to promote creativity and innovation by providing creators and owners with incentives to invest their time and resources in creating new and useful works. So you can control how your work is made public. You can make money by licensing and selling your creative work. And you can prevent other people from using your work to promote their businesses. So this is one of my favorite images as a great way of demonstrating a number of types of intellectual property all in one place. Obviously, it's an ad from Coca-Cola, and I'll talk about whether I have copyright for this image later, copyright permission. So first, in this image, we can see we have trademarks. Under Section 17 of the Commonwealth Trademarks Act, a trademark is defined as a sign used or intended to be used to distinguish goods or services that are dealt with or provided in the course of trade by a person from goods or services dealt with or provided by a different person. So a trademark can be registered, which means it has passed a formal application process and is listed in the official database of trademarks. And this is signified by that R in a circle. Or it can be unregistered, which means a business has been using it consistently to identify its business over a period of years, and it's gained a significant market reputation in that name or logo, but it has not undergone the formal registration process. There's a lot to talk about with trademarks, again, but I won't go into much detail today as it's a whole other webinar's worth of things I need to talk about. There are quite a few blogs on the topic on my website if you're keen to know more. And I'll talk more about the Serenity Connective at the end, which is another place where you can spend this whole month playing with trademarks and intellectual property in all its forms. For now, from a safety perspective, it's essential for you to know that there are severe penalties for using that R in a circle on a trademark that is not officially registered. So don't do that. And if someone is using that R in a circle, then they have exclusive ownership over that trademark in the country where it's registered and the categories or product or service that it's registered under. So basically speaking, if it's got an R on it, steer clear of anything that could be deceptively similar and never stick that R on anything of your own unless you are absolutely certain that it has gone through the trademark registration process and been formally approved. So what I want to show you here is a really quick look at the global brand database so we can talk about what these actual trademarks are that Coke has here. And I'm going to stop sharing that screen and then share this screen, which is the World Intellectual Property Organization's global brand database. Can everyone see that? So I've actually gone to the wrong page here. They've changed their setup, but I have it as a link that I can go straight to. Okay, so it's just brand DB was the bit that was missing to take me straight to their quick search. Okay, and so I want to search for Coca-Cola. As you can see, there are over 10,000 hits. So 10,041 hits of trademarks for Coca-Cola. So let's narrow that down to trademarks that are currently registered. So these are trademarks that are registered anywhere in the world. And we can see most of these first hits are from Japan. So we've narrowed it down to trademarks that Coca-Cola has registered, and we can see there are more than 5,000. So now we're going to tunnel down by location and take it back to Australia. There we go. And that brings us down to 145. And that's what I want to show you, that it's not just the name. So you can see Coca-Cola, the logo in many different variations has been registered. And the name itself, without any trademark variation, has been registered. And you can see down here, it's in different classes. So it'll be in the soft drink class and it'll be in the beverages classes and various things. So they've registered the words themselves, the name itself. They've registered the various graphical representation of the word in the fonts and the similar. And you can see here, they've also registered the shape of the bottle as a trademark. So that is a sign used to distinguish Coca-Cola from any other brand of soft drink. You can't register, you can't create a soft drink that uses the same shape of bottle as Coca-Cola, because that distinctive bottle design is also part of its trademark. So now I'm going to go back to my slides. So if you want to use the global brand database, you can just type WIPO or global brand database, WIPO, or global brand database into Google, and that will bring up that site. And it's a fun place to play and just have a look around. Now, obviously, Coca-Cola is a huge corporation. Most small businesses will only have 1 to 5 registered trademarks, not thousands. And now, if you look really carefully, I've blown it up for you. You can see that over here on the end of that Open a Coke, Open Happiness slogan, you can see there's a little TM to signify that that phrase is an unregistered trademark. Now, I'll talk about this more in connection with copyright, but there is no copyright in words or phrases because they are not significant enough to form a creative work. Instead, if words or phrases are used to identify and promote a business, they can be a trademark. So hashtags, slogans, product names, taglines, these are all trademarks and protected under trademark law, not copyright. Now, you can stick that little TM, that unregistered trademark symbol, on anything without formal registration. However, you do need to make sure that you have done your due diligence searches first to make sure that it is unique and original enough for you to claim ownership of it. And if you need help with that, you can look on my website for the due diligence consultation. And that's where I do the searches with you and provide you with a full report at the end. But definitely, if you have been using a name for a long time, you have a significant market recognition in that name, and you have done your searches and assured yourself that it is unique to you, then you can stick a TM on it without a problem. So next time you're shopping for groceries, take a moment to look for the R in a circle and PM symbols. It's always fun. Now, you might also be wondering why I use trademark as 2 words. That's the correct way to write it under Australian and British legislation. Trademark as 1 word is the American usage. And I think they're the only ones who do that, but I'm not certain. I haven't actually searched that out. Haven't researched that, but I can definitely say that trademark as 2 words is correct in Australia. Okay, so the next piece of IP we can spot in this example is the content of the bottle. Now, the recipe for Coca-Cola is a trade secret that has been closely guarded since its invention in 1886. As it was an original and novel invention, they could have applied for a patent, but this would have exposed their recipe to the public once that patent expired. Trade secrets aren't protected under legislation like copyright and trademarks are. They are only protected under contracts. So if you have your own modality, your own secret source, your own unique and original ideas, concepts, and processes that you teach to your paying clients, and you want to retain exclusive ownership of those secrets, A, you can hint about them on social media, but don't share them publicly. And B, make sure you have a contract with all those you do share with that clearly communicates what they are and are not allowed to use your trade secrets for. This may not seem like a big thing, especially if you're at the beginning stages of your business, but just bear it in mind. I have written many, many licensing agreements over the past few years for more established business owners who have, after spending years using their modality or their concept or their unique idea with their clients, they have now at the stage where they've developed practitioner training programs where they train and license their trainees to then go out and use their those trade secrets in their own work with the clients. And that allows the creator of that modality or idea or concept to reach audiences beyond what they can reach on their own. And also because of the licensing fees that they get paid by their trainees, it also increases, it's an income stream, increases the advantages that they get from those trade secrets. Again, this is a much larger topic and a subject for a completely different webinar, but to keep your IP safe, consider what parts of your work might count as trade secrets, your secret recipe, and keep them close to your chest and only share them with people who are contractually obligated not to disclose them without your permission. If Coke can keep their recipe secret for over 100 years of active trading, so can you. And finally, we get to copyright, which is what I'm going to be talking about for the rest of this webinar, as it is the type of intellectual property that is most relevant to using social media for your business. The copyright we see here in this advertisement is the composition of the digital image. So the photography of the guy and the bottle with the water on it, the photography of the ladybug, each of those would be elements that have copyright in them, and then they're composited into an image arrangement, which also has copyright protection. Okay, so let's move on and look at copyright in more detail. Now, I'm not seeing any questions pop up in the chat, so I'm hoping that means that that's a relatively clear explanation of the 3 different types of IP, and that you've all got your head at least a little bit wrapped around what a trademark is, what a trade secret is, and how they're different from each other, and where copyright fits into that mix. So I just want to repeat this in case it didn't sink in the first time I said it. Ideas and concepts are not copyright. They are trade secrets that are only protected by contract. Words, names, and phrases are not copyright. They can be protected as trademarks if they are unique, not generic, and used to identify your business. Copyright only protects creative work. Now, creative works means literary works. So what's literary work in the context of your business? It's your blog, your social media posts, your ebooks, your program content, your workbooks, your manuals. Graphic works, these are your photos, your drawings, your promo images, your logos, which are also, a logo can have copyright and trademark in it, trademark rights in it. And quite often the copyright ownership will belong to the graphic designer who created it for you rather than you yourself. You only have a license to use it. They still own the copyright. Dramatic work. These are your videos, your webinars, your meditations, and your Facebook Live. And musical work. These are your songs, your instrumentals, background tracks. Light language would come under that. Meditation could be dramatic works, could be musical works, depending on, like sound baths, meditations would be a musical work. So, just because you thought of it first or put a hashtag on it and called it mine doesn't mean it is. Copyright does. Okay, so there's a question, do we need to put a C on it when publishing our work, or is it automatically copyright? Guess what? That's my next slide. In Australia, copyright law is governed by the Commonwealth Copyright Act 1968. Copyright law protects original, literary, dramatic, musical, and artistic works, as well as sound recordings, films, and broadcasts. And again, copyright law does not protect ideas or information, but it does protect the specific expressions of those ideas and information. So here's a metaphor to help you understand that. Imagine you're at a cafe and you're telling your best friend about a brilliant new business idea you've had, and you sketch a quick diagram of your idea on a napkin. That diagram on that napkin is copyright. The moment you produced the work in a fixed form, it was protected under copyright law. If you recorded your presentation on your phone, that would also be protected under copyright. Now, your friend's awesome and wouldn't steal your idea, but knowing that it's better to be safe than sorry, you get her to agree that anything you share is confidential. So you now have an oral contract protecting your trade secret. However, if you just blurted your concept out and were overheard by a random stranger, there would be no contractual protection of your idea, and the stranger could take your trade secrets and do what they liked with it. Where if they took the design on the napkin, they would be stealing your copyright. So I hope that illustration makes sense. Now, to protect your content from copyright infringement, it's always a good idea to include a copyright notice on work that you care about your ownership of. This notice should include your name and the year of creation, and you can see mine at the bottom of the page. You can also watermark your work in other ways, such as by signing a painting or putting your logo and URL on a social media image. These are all ways of allowing people to identify you as the owner of copyright in the work. Having the date or a date range on a resource that is regularly revised or has new content added, like a blog or a website. So it might be 2015 to 2023, for example. That assists you in proving priority if someone else creates a deceptively similar work and you need to establish that yours was created first. And it also helps people know how long your blog has been running for and that it's being regularly updated. While copyright exists, so we're in a new year, so everyone should go and check your website and make sure that the copyright notification has been updated to the newest year. While copyright exists, even without the notification, having it there makes people think twice about using your work without permission and reminds them that there are legal rights involved. So yeah, it is a good idea to include the original year of creation as well as the current year, unless it's been significantly revised. So if, for example, I used this slide in 2018, but this year I significantly revised it and I included a whole pile of other information. So as a result, I've decided to just start it fresh as the 2023 work. I could have put 2018 to 2023. If you bought one of my DIY packs, you'll see that they have a date range from the year of creation to the year of, to the current year when they were last updated. So if you're creating, where are we? Yeah, so copyright exists automatically. The moment you produce the work, you own the copyright in it. But in order to put people on notice, it's a really good idea to put that copyright symbol on in some way, watermark it in some way, because having it there makes people think twice about using your work without permission and reminds them that there are legal rights involved. Now, if you're creating significant works that others are likely to want to use, you might also want to register your work with the Australian Copyright Agency. Australia doesn't require any registration of copyright. But if you do register your work, the Australian Copyright Agency is a not-for-profit organisation that manages licensing permissions and royalty distributions for creator members, particularly educational, commercial, media and visual arts licenses. So it's a good idea, for example, if you have an industry-specific ebook that you've self-published, you might want to register it with them so that they can tell if it's being used by others. I have a client who produces a lot of music and she registers hers and she gets a lot of royalties through them. Do you copyright your name, the business name, or the company name? It depends who is the owner of the copyright. So if you created the copyright for your business, you might want to use the business name. I could have put Copyright to Carefree Counsel there because that's registered as my business name. If I had a company, I would definitely put the company name. Because I'm a sole trader trading as Carefree Counsel, I've chosen to use my own name as copyright name. Simply because I haven't been using Carefree Counsel as a business name for that long and I have a greater market recognition. If you want to put your own name on it and you're licensing its use by your company, then that's a different aspect altogether. So it's a bit of a complicated question, but in most cases, if you're happy being identified as the creator of the work and if searching your own name will find you, then use your own name. If you're more widely known under your business name, use your business name, but only if it's registered as a trading as name on the ABN register. And if you're a company, you would generally use the company name because the company is a separate entity. Okay, so what is copyright really? Copyright is actually two different types of rights: economic rights and moral rights. Economic rights in relation to copyright refer to the exclusive rights of a copyright holder to reproduce, publish, and sell their copyrighted work, as well as the right to authorize others to do so. And these rights allow the copyright holder to control the use and distribution of their work and to earn money from it. Moral rights, on the other hand, refer to the non-economic rights of a creator of a copyrighted work, such as the right to be attributed as the author or artist who created the work, and the right to object to any derogatory treatment of the work that could damage their reputation. So these rights are intended to protect the personal and reputational interests of the creator and are distinct from their economic rights of the copyright holder. And they could be two different people. As I said, with a logo, if you've been assigned or the copyright has been transferred to you so you own full ownership of the copyright in your logo, you own the economic rights. The moral rights still stay with the designer who created it for you. Because moral rights are intended to protect the personal and reputational interests of the creator. They cannot be transferred or assigned to any other person. This means that even if a creator has transferred or assigned their economic rights in a work, they retain those moral rights and can still exercise them. However, it is important to note that the creator can waive some of their moral rights if they choose to. So in most cases, the graphic designer will waive their rights to be identified so that you don't have to give them a credit every time you use your logo, because they've waived that moral right to be identified. However, if you started using your logo on a product or service that they felt was distasteful and could damage their reputation, they may have the moral right to object to that. So copyright is very long-lasting. It lasts for the life of the creator plus 70 years before the work ends up in the public domain. So it is usually best to assume that copyright applies to a work until you've thoroughly researched it and satisfied yourself that it's definitely in the public domain. I had an inquiry from someone this week who wants to take a famous Australian poem that was written in 1905 and create a mural for it on the side of a public building. And they thought because the poem's more than 100 years old, that it would be safe to do so. And I had, a bit of research showed that the author of that poem, the poet, died in 1968. So the copyright in that poem doesn't actually expire until 2038, I think the math was. So what they need to do is then contact the estate of the poet and ask for permission if they want to do that work, because it's not yet in the public domain. Copyright protection also applies worldwide, although it can be harder to enforce internationally. So there's a question here. In the instance that we adapt a diagram or graph from literature as part of our teaching material, how does copyright work in this situation? Do you need to write and ask for permission? And I will cover that as we go forward. So first I want to talk about what happens when your own copyright is infringed. So now we have a good understanding of what copyright is and what it protects. Let me talk about what your options are if someone does copy your work without your permission. First, you're going to need to notice that the infringement has happened. This could come up in a number of ways. You might be doing a Google text or image search. Last year, I did a search for certain unique phrases in my website terms and conditions DIY pack and found over 200 people using my work who had not purchased the pack through me. Plagiarism software is another good resource, and there are several free options to use out there. Now, Cash Corbin posted in her group the other day that she was running her takeoff sales page through Grammarly, and it got flagged for plagiarism, which she knew wasn't right because she'd written every word of it herself in 2015. And when she went looking, she found 2 people who had stolen her sales copy for their own purposes. You can do keyword searches on Facebook. While keywords and phrases are not protected by copyright, remember they're trademarks, using keywords and phrases that are unique trademarks for you in your searches can be an effective way to find people who have taken chunks of your copy for their own, as well as putting you on notice of a potential trademark infringement, which is something different again. The more well-known you are for the uniqueness and originality of your work, the more likely your clients, friends, and audiences are likely to recognize your work if it appears in any context outside your legitimate business. And sometimes you might just get lucky and stumble across someone doing the wrong thing. With the rise in artificial intelligence crawlers out there, there is a whole industry of people who will now search for your images and hunt down those who use them without a license, similar to the copyright agency, but with more of a commercial emphasis. And they tend to be a bit more nasty about the way they chase things up too. So we all need to acknowledge that the risk of copyright infringement exists. It's a no-brainer. If your work is awesome, someone is going to want to copycat it. Above all, remember that even if they take your carefully crafted words or images, they can't be you. And it is you that your clients pay to experience. So before you go off the deep end, when you find a problem, breathe and feel flattered. They wouldn't try to take your stuff if they didn't think it was brilliant. And honestly, the more unique and original, the more you stamp your own personal mark on something, the harder it is for them to get away with it. Any other lawyer who used any of my stuff for in their marketing would be instantly obvious because, there's no other lawyers who do things just like me. But once you've calmed down and gotten over the shock of finding out that someone's taken your stuff, you have to decide what, if anything, you're going to do about it. And there are a number of considerations here. Just because you own the copyright doesn't mean you necessarily have to enforce it. There's a whole continuum of possibilities, and where you sit on that line will be unique to you and your gorgeous individual approach to your business. At one end, there are those who believe that all information is shared and they're just downloading from a common source. So there's no issue of ownership. And at the other end, there are those who crouch protectively over their work, stroking it and muttering, "My." Now, I suspect you will, like me, be somewhere in between those two extremes. So the results you want and the way you respond to an infringement is going to be completely individual to you, and there is no right or wrong. You need to approach it on a case-by-case basis. Factors that might influence your decision-making include whether the infringement was for someone's personal use, which you might choose to turn a blind eye to, or whether they're using your work commercially in their business, which you might consider to be completely unacceptable. While ignorance is no excuse in relation to copyright infringement, you might consider whether they have used your work innocently or accidentally, or if it is a flagrant, malicious, or calculated act on their part. You might consider whether their use of the work will damage or enhance your reputation. And finally, you'll need to think about what you actually want them to do. It could be to take down the work. It could be to give you an apology. It could be to pay you for the use that they've made of that work. And then finally, take action. If you suspect that your content has been infringed, you can try to contact the person who is using your work without permission. Now, my warning is always don't go in all guns blazing, because I've found that a gentle approach often works extremely well. Let them know what the problem is. Assume they're acting from a place of good faith, unless you've got proof that they're being malicious. And if you've got proof they're being malicious, then you'd want to lawyer up sooner rather than later. But if you can just assume that they've made a mistake and approach your correspondence with them from that context, it gives them an element of a way to apologize and back out without losing face, a way to do it graciously. What are some of the proofs of maliciousness? That's going to be on a case-by-case basis. Usually it would be because you've got some prior relationship with them. It depends on how it feels, I think. But yeah, so if you are approaching them gently, let them know what the problem is, establish your ownership of the work, and clearly request them to take the action you require, whether that be giving you credit, taking the work down, or paying for the right to use it. If this doesn't work, or you can't or don't want to contact them, the majority of social media platforms also have ways to request that copyright infringing material be taken down. And I'm going to quickly share my screen and show you how this works for both Facebook and Instagram. So stop sharing there. Hello, everyone, and start sharing. All right, this is Facebook. The way to find it on Facebook, it can be a bit tricky. So you click on your profile picture and you go down to help and support. And then you go to the help center. And then you go to policies and reporting. And down here, you can see there's intellectual property and copyright. There's also a trademark. And you can see they're an American brand because they put trademarks one word. So there we go. We've got copyright. And then we've got all of these lots and lots of information that you can read, FAQs. And then we go to reporting copyright infringement on Facebook here. How do I report copyright infringement on Facebook? If you click on that, you can report it to us by filling out this form. And if you click on that form, you can see I am the rights owner. I'm reporting on behalf of my organization. So if you're a company or client, or I'm reporting on behalf of someone else. But usually you would report it on yourself. And if you don't get action, you can get other people to report on your behalf. So you can ask friends to report it as well, if it's been posted where they've seen it. You put in your information, your mailing address, your email address, the country that you're based in, the name of the rights owner, description of the type of work that's being copyrighted, the type of work you're reporting, little description of the content, the URLs, why you're reporting it, because it copies your work, you appear in the content or it uses your name, and then any additional details that can help us understand the report. And then you're signing it to, which is a legal thing. It's you're making a legal declaration. So don't do it without it. And then you submit it. And then for Instagram, same thing. This is Instagram and my account. You go to the little more down the bottom here in the left. When you click on that, you will get to settings. There we go. Settings. And then you go to the help there. You go to the help center. Now, is that right? Help center. No, Instagram's tricky. Sorry, if you go to help, you go to the privacy and security help. That was the one. Was it? Yes, reporting content. No, reporting content you don't like. They've changed it since the last time I looked. I love it when they change things on me. Where is it? Support requests? Reports. No, that's people that you've reported. Privacy and security help. No, it should be privacy and security reporting. Help center. There we go, privacy and security reporting. I was right in the first place, I just didn't look in the right place. Okay, privacy and security reporting. How to report things is there. And there we go. Report intellectual property infringement. How do I report copyright infringement? Fill in this form. And it's the same form that we had on Facebook. Okay. All right. So as I said, check your facts carefully. Copyright infringement is a serious legal allegations and there may be penalties for making false reports. Collect your evidence, your screenshots, URLs, dates and times, then read the facts and submit your online form. Note that the person you report will be given your contact info and encouraged to resolve issues directly with you. All right. I'm going to run over time from the way I'm going. Sorry, it's taking more time than I thought. So I'm just going to speed up. All right. Yeah. All right. So if you can't get satisfaction that way and you want to get more serious, you can go to a lawyer like me and get me to write a formal cease and desist letter and negotiate with the infringing person to hopefully get the result you want. Depending on how argumentative the other person is and the strength of your claim, this can cost at least a few $100s. It may be worth it if your content has been posted commercially or in a context which is harming your business reputation. If you discover someone actually selling your content and making a profit from it, or if you're worried about repercussions and would prefer not to deal with the matter yourself, then a lawyer is a good idea. If a lawyer cannot negotiate a successful resolution and you really want to pursue the issue, you might consider mediation, which will generally cost in the region of $1,000 to $2,000, or litigation, which can be extremely expensive and run into tens of thousands of dollars. In Australia, there are only civil law remedies for copyright infringement. That means if your cease and desist letter doesn't work, you have to take the infringer to court or mediation and claim damages or an account of profits. Damages is compensation for money that you have lost, such as lost sales, or spent, such as legal fees, in relation to the infringement. So you might be able to, if you win in court, you might be able to get some of your legal fees back. You won't get them all. An account of profits means that the infringer has to repay you any profit that they may have made by illegally selling the material that infringes your copyright. Copyright infringement can also be a criminal offence, but this usually only relates to commercial piracy of music, videos, or computer software. All right, when I changed back, it flipped slides, so I'm sorry about that. We jumped ahead. Best practice for protecting, for sharing other people's content. One common trap that business owners can easily fall into is believing that something is in the public domain just because it's freely available on the internet. And this is not always the case, and you should always check for copyright before sharing or using someone else's work. Be very careful when using images, music, or videos from the internet, as these are often protected by copyright. You're still at risk of copyright infringement, even if you got the content from someone else, can see other people using the content as well, give credit to the original copyright owner, add a disclaimer like I don't own the rights or no infringement intended, or have added your own material to the original content, or even if you didn't copy the whole thing and just took a little bit. It depends on how little is little. It is possible to infringe someone else's intellectual property rights even without meaning to. So it's important to always be aware of where you're getting your content from and whether or not you actually have the right to be using it. The easiest way is to only ever use your own unique work. And of course, I understand this isn't always as easy as it sounds. But remember, there's no copyright in ideas, only the expression of those ideas. So if you see something that inspires you and you want to use it, like a diagram or an image or something someone said, take the time to express that information in your own way, drawing on your own personal expertise in the area, adding your own spin to it, and using your own creativity and imagination. Create something that is unique to you, even if others have talked about the same idea or topic or concept before. Be original and inventive with the way you present, explain, and teach the content. Show respect for the other person's efforts and put your own equal effort in to make the idea your own. Innovation is always better than copying, so set your imagination free and ask yourself, what else is possible? Make it better. Take your own photos, buy them from a stock library such as Shutterstock, Creative Market, or Canva Pro, or use one of the free resource libraries such as Pixabay or Unsplash. All of these are fine for commercial use, but check your licensing. For example, I've bought some gorgeous dragon images from Shutterstock, but they were only digital licenses. Before I could print them on physical products, I had to pay for an upgraded license. So, for example, this dragon, let me stop sharing for a minute so you can see my screen. Yeah, this dragon that's on my Castle Quest journal that I sent out to Castle Quest participants this year. I had to buy an additional license that allowed me to print it on the journal. Or my lovely mug here, which has the Castle Quest logo on it, and also has this gorgeous dragon. I bought an extended license that allowed me to print and use this. I'll be giving away some of these mugs and journals later in the year when I run my Future Proof Your Business challenge. So watch out for that. Going back to sharing a screen for the slide. But remember that fonts can also be copyright. Google fonts are free for commercial use, but others, such as Adobe fonts, may have specific licenses attached to them. Do your research and know what your license allows you to do. If you purchase photos or images from an artist, photographer, or graphic designer, ask them who owns the copyright and if there are any restrictions on the license they've given you to use those images, and get it in writing. Email is fine. Now, there are a lot of questions coming through now, and I'm going to have to answer them outside the webinar because I'm running out of time. And I do have some more I want to cover for you. But please keep the questions coming because I will answer them. If you do want to share something you've found on social media that was created by someone else, you can use the built-in sharing functions in Facebook and Instagram and Twitter, for example, and LinkedIn, to repost the other creator's original content. Before doing this, make sure you're satisfied as far as possible that you trust the integrity of the original poster and that it is their original content, as otherwise you risk secondhand copyright infringement. Sharing like this ensures that the image links back to its original source, and if they didn't want it publicly shared, they would have restricted the sharing permissions. Something to remember for your own content as well, that in Facebook you can restrict sharing permissions on a post-by-post basis. It's a lot safer than saving the image and reposting it, even if it has a watermark or signature or similar. Copyright prevents copying a significant portion of the work. So a small quote from a larger work is acceptable with attribution. So as a result, it's fine to take an inspiring quote and present it on your branding, so long as you reference the source of the quote. Just the author's name is usually sufficient. So you'll hear me saying all the time how much I love Brené Brown's concept, clear is kind. Yeah. In most cases, the same principle would apply to quoting a paragraph from a larger work, particularly if it is done for a fair use reason, such as education or discussion of a relevant topic. Sometimes that can even apply to an image. So, for example, the Coca-Cola advertisement I shared earlier, which I shared for educational purposes, in no way conflicted, competed, or subverted the original purpose of the work. Hi, Alice. I'm running overhead on my webinar, so you're welcome to stay and watch the end of it. So remember that what's significant in terms of sharing part of a larger work depends on the circumstances. You need to consider whether that part of the work you want to use is an important or integral part of the work as a whole, the amount of time and skill that went into creating that part of the work, and whether the use you intend to make of that work is fair and reasonable, and in accordance with the author's design for the work as a whole. In most situations, sharing a short quote from a larger work has the potential to attract new readers and enhance the writer's reputation as an authoritative source, so they'd have no objection. However, put yourself in the author's shoes and think about your intended use. If you have any doubts about how they might feel, the safest course of action is always to ask for permission. Sorry, Alice, you hadn't joined properly before. I was just saying my webinar has run over time. You're welcome to stay and watch the end of it, or I'll chat to you later. Alice is coming in for a Serenity Connective check-in call, which might not happen today. Yeah, so put yourself in the author's shoes, think about your intended use, and if you have any doubts about how they might feel about your use, the safest course of action is always to ask for permission. And in all cases, you would want to make sure your intended use is respectful and not in any way derogatory or damaging to the author's reputation. Asking for permission can be as simple as sending a message or email to the creator saying, "I love your work. Do you mind if I reshare this information from your newsletter on my Facebook business page? In other cases, you might need something more comprehensive, like a full licensing agreement. I'd really like to include your information about this topic in my upcoming workshop. Would you be interested in collaborating with me? The kind of permission you require will vary depending on the content, how big the creator's brand is, and how you want to use the work. If they've pasted it on their Facebook business profile and it's available for public sharing, then sharing it on your page is fine. They've given you permission by providing it in that situation. However, if you're a competitor of theirs, or sharing their work is likely to offend them in some ways when you put yourself in their shoes, then you would want to ask permission. Now, in order to ask for permission, first you have to find the creator, and this isn't always easy. Searching for a text is relatively straightforward, so I was going to demonstrate how to trace an image back to its source, but this can be really time-consuming. So I think what I'll do is I'll demonstrate it as a Facebook Live, and I will send out the link to that video to the mailing list once I have done it, rather than take up extra time for you today. Finally, remember that you are responsible for everything posted on sites you control, even if you don't personally post it. So ensure that you have consistent policies about using copyright material, and that anyone posting on your behalf respects that and understands what is and is not acceptable. I've had clients who have been sent copyright infringement notices for things where their VA has just made a mistake and they still had to pay for it. So, memes and viral content. Let's look at memes. Memes could be said to exist in a copyright no man's land. A meme is usually a copyrighted image with added text, often intended to be funny and attention-grabbing. They are little pieces of content that the creator usually hopes will become popular and spread widely across the internet. They may even go viral. However, meme can also refer to a combination of image and text, often a quote, used in marketing on social media under a business's branding, although not directly selling or promoting something. So every time you create your own images with quotes and things like that, you're creating memes. When a meme goes viral, it spreads rapidly around the globe, generating a phenomenal amount of attention in the form of likes, shares, and comments. Identifying the source of a viral meme can be incredibly difficult, particularly given the tendency to riff on memes, produce your own variant. And there are companies out there that have create your own meme apps and similar. Memes are they're made to be shared widely for the fun of it, unless they're made for a commercial purpose. If a meme has watermarking or copyright information on it, never ever remove those identifying marks. And think carefully about whether you want to use a meme with someone else's branding on it in the context of your business. You might want to create your own instead. Put your own unique spin on it. If a meme uses the image of someone famous, like the ones I've shared here, think twice about using it if there is anything unfavorable to the person depicted. If it could possibly damage their reputation, it's generally best to steer clear, even if everyone else is using it. But in general, these come under the fair use kind of virally safe things if they're not at all offensive. So if you have questions or want to learn more, there are 2 ways to work with me on this. You can book a 1-hour intellectual property strategy session for $440 through my website, and we can talk about anything you want to talk about in that session. Or you might like to consider joining the Serenity Connective, which is my membership. We have monthly missions, and our mission in February is all about intellectual property. It's called Eternal Vigilance, because intellectual property is never a one and done thing. It's something you need to come back. An intellectual property strategy session lasts for an hour, but we can cover an awful lot. You can see in how much I covered in this hour. Yeah, and so when we're targeted in on what your actual questions, I can usually answer pretty much everything you need to know in that hour. So in the Serenity Connective, our mission in February is intellectual property, and we'll be doing a thorough audit of all our intellectual property assets. There is a recorded mission briefing where I go into much more detail about the other types of intellectual property, a 60-minute curiosity call, which is like a mini mastermind where we discuss the topic and I answer questions. And there are also 3 30-minute challenge check-in calls where you can ask me anything. And that's what Alice was turning up for earlier. The other person who booked in today was Robin, and she's on the webinar, so I assume she's happy to wait for a few more minutes. There are also daily journaling prompts in the Facebook group to get you really exploring what your intellectual property means to you and to your business, and heaps of co-working time if you need accountability to get things done. So Jodie's asked, in the Serenity Connective, can we ask questions about the legal issue we're working on at the time if it's not on the monthly mission? That's what the challenge check-in calls are for, absolutely. Having said that, I will not give you legal advice within the Serenity Connective, but I'll give you legal information. And there's a very fuzzy grey line. So yeah, I can usually answer your questions and give you ideas for how to approach it within the challenge check-in call. And yeah, you can talk about challenges within the group even if they're not on the mission. And there's also, so for $165 per month, you get the whole, or to join us just for a single month mission, or you can get a whole year's worth of mission and explore all of those important essentials for business owners like boundaries, saying no, clearing your endless to-do list, putting out those hotspot fires that are constantly cropping up in your business, reflective practice, embodying best practice, improving your communication skills, and so much more. So every month we have the curiosity call, which is to discuss the mission, and then we have at least 3 challenge check-in calls. And there's co-working pretty much every day available, except for Sundays because I don't work on Sundays. So Serenity Connective is joyful adulting for brilliant business owners. That's how the people who are currently in the membership describe it. Joyful adulting for brilliant business owners. It's $1,100 for the whole year, or there is the private mentoring option, which is actually the cheapest way to work with me. For $2,200, you get all of the Serenity Connective for the whole year, all of the calls that are part of the membership, and you get 4 hours of my time that you can just use for you however you want it. So what I do is I give you booking links for 15, 30, and 60-minute calls, and you just book in whenever you want throughout the year to talk about whatever's coming up for you, one-on-one with me, and until you've used up your full 4 hours. You can find more information about this on my website as well. So there we go. Any questions? Now's your last chance to put them in the chat. I didn't go too far over. I made it only 10 minutes more. That's good. In summary, connect. Ask for permission before sharing an image, artwork, article, or substantial quote. Or post a précis explaining the relevance of a blog post or article to your work area and make sure it links back to the original source, or seek collaborative permission or similar. Care. If you can't contact the originator or share from the source with attribution, don't post it. And consider yourself to be a content curator. Yes, I will absolutely make the slides available as well as the recording. And as I said, I will do the Google image search. Probably not as a Facebook Live. I think I'll do it using Zoom so that I can make sure I can get it really clear for you. And then I'll share the link out in the into the mailing list with the recording. I'll send it out with the recording so you've got that. And create. Make something original that conveys your message just as well, and always use original content to sell and promote your own work. Just quickly flip back through. Sometimes memes are based on movie stills. Are these especially risky? Not particularly, so long as they're not derogatory of the movie, because the movie is, it's kind of meant to be, it's like a quote, taking a quote from a book. You know, it's iffy, but it's unlikely to be hunted down. So on levels of risk, it's kind of towards the low end. So like, sticking a picture of Baby Yoda or whatever out there, or Lord of the Rings or whatever. Yes, it's copyright. Are they likely to enforce it? Probably not. So it's a lower risk. I answered that one. If a business has a publicly visible page and built-in share function, yes, you can share it. We did that one. How do we set our innovation apart from it being a copy of someone else's work? That is a case-by-case question. I can work with you on ideas, either in the Serenity Connective or in a intellectual property strategy session. But yeah, that's a how long is a piece of string question. What makes it innovative? What does your gut tell you? Have you changed it enough to make it unique and original and put your own spin on it? If you've read a concept in a book or heard a phrase that inspired you on a podcast and decided you wanted to write about yourself, you can acknowledge where you got the idea and then you can freely write about it in your own words. Absolutely, yes. And I think that's back to where I got up to. Is there like a percentage? No, there is no percentage. It's the copyright legislation says a significant part of the work. So it really is a case-by-case assessment of whether the piece that you're taking is significant and whether it's recognizable, and whether you've copied as something that is significant to the original work. It's really an individual piece-by-piece assessment. All right. So that was my webinar on sharing safely. I hope it was really useful to you. If you've still got more questions, you're welcome to post them, send them to me however you like, on email or Facebook message or whatever. I'd be happy to answer them. And thank you very much for joining me. It's been a great pleasure to have you with me today.